For our last panel of the day, I'm pleased to introduce Judge Thomas Hardiman of the Third Circuit Court of Appeals. Judge Hardiman received his BA from Notre Dame and his JD from Georgetown University Law Center. He served in private practice before being appointed to the Western District of Pennsylvania in 2003 by President George W. Bush, and in 2007 he was appointed to the Third Circuit. So please join me in welcoming Judge Hardiman.
Thank you for having me. It's a great pleasure to be here, and thank you to the Columbia chapter. This is the biggest lecture hall I've ever been in, I think, and it's full. So it must have been a daunting task to organize this convention. So congratulations on doing so, and thank you. I'm confident that you're more interested in hearing what our esteemed panelists have to say rather than having me prattle on about their long list of accomplishments, so I'll keep the introductions brief. We'll proceed, as we usually do, with a wonderfully diverse group of speakers. Each speaker will open for 10 to 15 minutes. Then we'll have some discussion among the panelists, which I'll do my best to facilitate. And then I would like to reserve hopefully close to a half an hour for questions. If Professor Epstein's still in the room, I'm sorry, your questions have been used up. So this is the Student Symposium, not the Law Professor Symposium. So as much as we do love hearing from Professor Epstein, I'll be seeking as many of your questions as we can get in on the tail end. I'll begin with our first speaker, Dean Robert Post of Yale Law School. He also serves as the Saul and Lillian Goldman Professor of Law. And I'm fortunate to know many members of the American Law Institute. I've met some members of the American Philosophical Society, and I've probably met some members of the American Academy of Arts and Sciences, but I've certainly not met anyone who's a member of all three. So that's quite a trifecta, Dean. On a more serious note, if you consult YouTube, you will see Dean Post surviving the ALS Ice Bucket Challenge, wearing a tie, no less. So I hope to find out why he decided to sport a tie for that wonderful charity. Our second speaker, Professor Philip Hamburger, is the Maurice and Hilda Friedman Professor here at Columbia Law School. He's a leading scholar of constitutional law and its history, and he works on a variety of topics, including religious liberty, freedom of speech, academic censorship, judicial review, and the office and duty of judges. He's written several books on very diverse topics, including church and state matters and administrative law. Also from Columbia, Professor Suzanne Goldberg is one of the country's foremost experts on gender and sexuality law and a leading advocate for the LGBTQ community. She serves as the Herbert and Doris Wexler Clinical Professor of Law, and she leads the Law School's Center for Gender and Sexuality Law and its Sexuality and Gender Law Clinic. You might be interested to know that she was co-counsel for the defendants in the landmark case of Lawrence v. Texas. Finally, our last speaker today, last but not least, is Professor Michael McConnell. He's a noted constitutional scholar and was that before joining the United States Court of Appeals for the 10th Circuit in 2002, where he served with great distinction until returning to the Academy. The judiciary's loss is the Academy's gain. And I hope one day to sit in on Professor McConnell's class at Stanford that he teaches on Plato's Republic. Without further ado, Dean Post.
Thank you, and thank you for the honor of being here. It's a great pleasure to talk to you today about the subject of freedom of speech in the university. As you all know, it's a highly controversial topic. If you just look on the internet on any given day, you can find Betsy DeVos saying the greatest difficulty in the academy today is recognizing the free speech rights of others. If you look at FIRE, the Foundation for Individual Rights in Education, you will see that the First Amendment rights should be protected in the university, and it's a great It's a great scandal that universities are falling down on their obligation to protect the First Amendment rights of professors and students. Their universities stand accused of intolerance and so forth and so on. So the basic assumption behind this, and it's an assumption that crosses the ideological spectrum from Jeff Stone on the one side to Fire on the other, is that the First Amendment type freedom of speech should apply in the university. So I'm going to play Richie Epstein for a second, and I'm going to say that that framing of the issue is wrong from the ground up. It misunderstands the way in which communications work in a university. So to understand why anyone would take such a ridiculous position, I think you have to start off by saying, well, what do we mean by First Amendment rights? If First Amendment rights are going to be applied within the university, we have to be kind of precise about what those rights are. So First Amendment doctrine is quite complex, contains a lot of rules. Let's just take 3 rules that anybody would say would be essential to the First Amendment. First, no content discrimination. You can't discriminate on the basis of content, subject to strict scrutiny if you do. Second, all ideas are equal. There's no such thing as a false idea for purposes of the First Amendment. Remember that rule. Third, you can't compel someone to speak. Now, I take it there are many rules in the First Amendment, but those 3 are pretty essential. You might ask yourself why we have these rules, and here's one explanation, one which I favor, but perhaps you can think of others. It seems to me we have these rules because when the court developed First Amendment doctrine in the 1930s, and remember, the Supreme Court did not protect First Amendment rights until the 1930s. It protected it primarily within the context of the ability of persons to participate in the formation of public opinion to the end, as Chief Justice Hughes would say, we can live in a free republic in which we govern ourselves. The value of self-governance is extremely important in the United States. How do we cash out that value? How do we govern ourselves when I can lose the election? And so I'm not governing myself. I didn't vote for Trump. In what sense am I governing myself? Answer, we are governing ourselves because we can all participate in the formation of public opinion, and the government is responsive to public opinion, and hence the First Amendment guarantees self-governance. Now that's an odd thing to say, because the First Amendment sets aside the result of majoritarian legislation, right? We use the First Amendment to invalidate what the democracy otherwise would pass, but it nevertheless protects democracy because it protects the preconditions of self-governance. So if you think of that as a purpose of the First Amendment, these 3 rules make a lot of sense. Why should we say no content discrimination? Because we don't want the government setting the agenda of public opinion. We want the government to be responsive to public opinion, but not creating the agenda to which it will be responsive. It's the people who set the agenda for government and not the reverse. And why do we say that all ideas are equal for purposes of the First Amendment? That's a very strange thing to say, that all ideas are equal. That's not normally the way we function. But we say it for purposes of the First Amendment because in a democracy, there is political equality. All of us have an equal right to form and to participate in the formation of public opinion. So there's a political equality at the heart of the First Amendment, which is embodied by this rule that I'm not going to second guess your idea. Your idea matters for purposes of self-governance because you matter for purposes of self-government, and everyone matters equally. And the third rule is a little more complicated, no compelled speech. Why is that? Because if the First Amendment is serving the purpose I just postulated, if it's serving the purpose of democratic legitimation, the government can't be responsive to me if the government is telling me what to say. Right? If I'm to participate in the formation of public opinion in the hope I will make the government responsive to me, if the government is telling me what to say, then the government isn't any longer responsive to me. Those are, I think, pretty basic explanations of those 3 rules. Now, take the university. Do they apply to the university? So let's take a simple example. Let's take students like you in a classroom. Do these 3 rules apply to your speech in a classroom? Is there no content discrimination in a classroom? Of course there is. If you're in my class on constitutional law, you're not talking about auto mechanics, I promise. What about all ideas are equal? No. They're not equal. That's called grades. What about no compelled speech? Obviously, that's not true. You take examinations. If I call on you, you answer a question. Right? It doesn't apply at all to students in the classroom. What about to professors in the classroom? Same thing. If a professor is supposed to teach constitutional law and I want to talk about the World Series, I have a problem with the university. All ideas being equal, I'm teaching mathematics and my equations are all wrong. Or I teach that there's no Holocaust in my history class. I've got a problem with the university. Or what about no compelled speech? Well, I have to teach my classes. I have to talk. These three rules have no application to professorial speech in the classroom. They have no application to student speech in the classroom. What protects student speech and professorial speech in the classroom? Academic freedom of teaching. That is to say, I have the freedom granted to me by academic freedom in the classroom to teach in a way that the profession recognizes as competent. I have to be competent in my teaching. That's the crucial judgment that my peers make about my teaching, and they're entitled to make that because the function of a classroom is to teach, and the function of a university is to judge whether I've done that competently. Now, there's great range in freedom of teaching because the function of, at least in higher education, this doesn't apply to secondary education, but in higher education, the function is to teach you to think for yourselves, right? To give you a critical intelligence. And that isn't a bit of information that can pass from me to you. That's the difference between teaching in a university, in a law school, and a bar review class. In a bar review class, the object is to give you the information necessary to pass the bar. In a university, the object is to make you want to think for yourselves and to become a mature adult. And how does that happen? Not by giving you a free pass to adulthood card. It happens because you see someone enacting a mature independence of mind, hopefully. That's the idea of competence. And it inspires you to think for yourself. Most students have someone that they identify with, a mentor, and they model themselves after that person. And because we want professors to create that form of inspiration for their students, the idea of professional competence and freedom of teaching, academic freedom of teaching in the classroom is quite broad-ranging. It is nevertheless not exempt from judgments of competence. And judgments of competence turn on whether the purpose of education is being served. That's why, as a professor, I can't abuse my students. I can't yell at them and call them names and hostile epithets and so forth and so on. That would be incompetent professionally because it would be inconsistent with their learning. So if you remember what happened to Elizabeth Warren, every deliberative body in the world has rules that you can't cast aspersions on individuals. Why? Because it's inconsistent with deliberation. Same in the classroom. This is inconsistent with First Amendment doctrine totally. Why is that? Because the classroom isn't a site of self-governance. In the classroom, we aren't governing ourselves. We are together engaged in a mission, and the mission is education. And the speech is governed by its relationship instrumentally to that mission. What about my speech as a professor in research? I have freedom of research, but do the three rules I just described to you apply to my ability to publish my research? And the answer is no. So content discrimination. If you are in, wow. If you are trying to get tenure in a linguistics department, you better not publish on sports or physiology, because that's not going to get you tenure. So there's content discrimination in the judgments we make about professorial research. What about all ideas being equal? Of course not. We judge the work of untenured professors as better or worse. And that's upon such judgments that the award of tenure is granted. What about no compelled speech? Well, you might have heard of the rule, publish or perish. If you don't publish, if you don't speak, you're not going to get tenure. Right? We apply these criteria of competence to professors in their research role, and we do not apply the basic rules that define freedom of speech. And why is that? Once again, because we hire professors to do a job. The job is research, and we want them to achieve that goal, and we have to regulate their speech in order to attain that goal. And that's not an issue of self-governance. That's not an issue of freedom of speech. And in point of fact, we protect the freedom of research through academic freedom of research. Academic freedom is quite different than freedom of speech because academic freedom protects, is subject to judgments of competence. Every university has to judge the competence of its faculty, does all the time. Freedom of speech precludes judgments of competence through the 3 rules that I just described to you. Moreover, freedom of speech, First Amendment freedom of speech, is an individual right. It's my right as a person to say what I want to say. Academic freedom of teaching is not the academic freedom of the individual, it's the academic freedom of the scholarly profession to make its own judgments free from the pressures of the administration or of the donors or whoever happens to own the university. So what's actually protected in academic freedom of research are the disciplinary rules by which the disciplines are, the departments are constituted. So simple example, I'm a professor, I want to get tenure, I've published a piece of work, they don't tenure me, it's an outrage, I go to court and I sue. What is the court going to do? So the court looks at the case, and if the court thinks this work actually deserved tenure, disciplinary standards were not correctly applied because, say, there was outside pressure or because there was bias, the court will fine for the professor, putting aside issues of deference. And if the court finds that disciplinary standards were properly applied, that is to say, this work really isn't that good, it will fine for the university. So academic freedom doesn't reside in the university, it doesn't reside in the individual professor, it resides in the disciplinary standards. The court is protecting the disciplinary standards that define competence in the field. Now, I understand the confusion that might occur because we are so often say to ourselves, gee, we protect freedom of speech, the First Amendment, because of the marketplace of ideas, and the marketplace of ideas leads to knowledge. People often cite Holmes. The best test of truth is its power to get itself accepted in the marketplace of ideas. But if you think about it for 2 seconds, that doesn't make any sense at all. There is no knowledge-producing sector of this society that goes off on a marketplace of ideas theory. No law review does a marketplace of ideas theory. You don't accept articles on a first-come, first-served basis. No professional journal, if you're running Lancet or Nature or Science, you make judgments of quality. And if you think about it for another second, you'll see that the premise that there's no such thing as a false idea would also mean there's no such thing as a true idea. And the whole enterprise of getting to knowledge would collapse. So wherever you see knowledge created in our society, you will see judgments of competence in a disciplinary context, and that means a hierarchical context in which there are authorities and not authorities. This is a complicated set of sociological conditions that define a discipline. It must be open to criticism. The price of being part of a disciplinary community is being perpetually open to criticism, but at the same time, a discipline has to decide what's real and what isn't, what's true and what isn't. So it has this motion, it has this difficult balance to maintain. So freedom of speech is really not a very helpful concept when it comes to understanding how students or professors' speech is regulated in a university. We see this mostly coming up in situations where academic freedom is not truly relevant, like in invited speakers. And then we have to ask, why does a university invite speakers? It doesn't invite speakers because it wants to be like a park, it wants to be a public forum. It invites speakers to serve its basic missions of research or education. And if that's true, then the issue of the freedom of speech or the selection of the speakers has to be judged by the same standards. And I take it one important mission of a university is to train students to be tolerant of the views of others, to understand themselves as citizens in a pluralistic world where a lot of people are going to disagree with them. So most major universities, most major research universities allow for a kind of quasi-public forum in the invitation of speakers. But they do so for educational reasons, and it follows from that fact that in any given case, the educational reasons may be so strong as to require the conclusion that this speaker is so disruptive as to be inimical to the university atmosphere and university mission. And once again, that's a judgment about education, not about freedom of speech.
Well, why don't I begin by saying a little bit about the topic, because we may see the topic slightly differently. Robert has treated the subject of disciplines, and indeed discipline, within the university, and there's a lot to be said for understanding what we do within fairly constrained circumstances. But in contrast, I'd like to talk about freedom, and in particular, free speech. At stake is not a narrow concept of academic freedom, but more broadly, and what sometimes is missing even in the academic context, intellectual inquiry. I've sometimes said that we're here to teach. Maybe. I'd rather think it's a more egalitarian enterprise. Both students and faculty are in these institutions in order to inquire, to engage in intellectual inquiry, not merely academic inquiry. And what one needs for this, above all, is freedom. Of course, there are disciplinary limits to this. One can easily go off topic. But then ridicule is the easiest solution to this. To inquire seriously, one's always having to upturn old accepted truths. And one sometimes steps on toes in the process. So freedom is necessary for this inquiry to flourish. And this is profoundly at risk. Universities are embracing conformity in all sorts of ways, not just the ways discussed in this panel. And at the same time, electronic communication is opening up inquiry outside these institutions. And the danger is that universities are going to return to what they once were, very expensive finishing schools. And by the way, given the behavior of both faculty and students alike, I'm not sure we're very good at being finishing schools. So, second, what's the nature of the danger? Put generally, the real danger is not any one thing, but an alignment of forces. There's not just one pressure for conformity, but many. There's peer pressure, accelerated by that same electronic media and popular opinion, especially in a democratic society. There are financial pressures, of which the university is always painfully aware, not to mention students increasingly. And then ultimately, there are legal pressures. And that is, I think, the most important focus here at a law school. And in that sense, I guess I'm going to be talking about intersectionality, because it seems to me, whatever one thinks about the distinct character of academic freedom or intellectual inquiry, the freedom necessary within a university, and that's a complex matter, does intersect with one's legal freedom, and sometimes in painful ways. So you might think at this point I'm going to talk about insults on campus and political correctness. I'm not going to do that. I want to go off in an entirely different direction that may seem actually out of place. I'm going to talk about an institution many of you will never have heard of, and yet it exists right here. That institution is the Institutional Review Board. I'm just curious, how many of you have even heard of an Institutional Review Board? Oh my. Well, that's more than I get at most events. Because we actually have formalized censorship of 17th century style in every university in this country. And it's worth remembering this because amidst all the complaints about political correctness, which are very serious, at the same time, we have to worry also about institutionalized censorship. This is real censorship. It's prior administrative licensing that requires one to get permission before one talks, writes, and publishes. The First Amendment says Congress shall make no law abridging the freedom of speech or of the press. Now, the meaning of this is disputed. Does it cover injunctions, post-publication restraints, to what degree, nonverbal expression? All that's very interesting. But there's no dispute about the core historical meaning, which is no prior administrative licensing. This was a rejection of the Star Chamber and of the Inquisition, which did this. There's an absolute bar against licensing of words. But such licensing has come back in the form of institutional review boards, so-called IRBs. Now, the goal was to avoid harm in human subjects research. And the moment you mention that, all sorts of images come to mind, sticking needles into people, injecting mercury, seeing what happens. It's just like, the concentration camps. Well, not really. But the point is that from this fear, the government, particularly HHS, developed a system of licensing. And whereas the old licensing in the 17th century was designed to protect the dignity of God, this is designed to protect the dignity of human beings. The federal government conditions benefits for universities on their establishing IRBs and their licensing. I should say, just as a caveat, I'm not talking about the use of IRBs under FDA regulations for new drugs and devices, in case you're aware of such things. That's not the topic here. There's another use of IRBs for controlling speech in universities. HHS sets the minimum standard for this in something called the Common Rule, but institutions develop their own additional rules. The universities uniformly cooperate. Why? Well, one reason is it's a condition of benefits. But it's more than that. Very early on, already in the 70s, the federal government realized it was in a somewhat awkward position imposing this. So it, for ways I won't bore you with, it encouraged the idea that state negligence law enforces these, and that's the main fear now of universities, and some states actually have their own statutes on the subject. So there's direct state action from the states these days. The universities establish the IRBs, and if I or anyone else here wants to just talk to somebody about them, read about them, even look at public records that refer to living human beings, one generally has to get prior permission in order to publish on it. The mechanics of this we can leave aside. Suffice it to say that if you do not cooperate, you will be told to stop your research, stop even thinking about the subject, stop taking notes, stop reading. You'll be told not to publish. If you have a publication lined up, you'll be told to withdraw. The journal will be corralled into withdrawing publication. And if you really persist, you'll be denied permission for any future research or publication, and you can even be declared unfit to do research, which means you can never publish academically again. This is 17th century licensing all back again. Now, does it really concern speech? Oh, indeed it does. The regulations define research in terms of speech, and without going, I won't parse the regulations for you, that would be a bit of a bore, but suffice to say, speech is what it's all about, and that's most of what the IRBs do. They control what's said. Even when they get to medical research, it's their main concern. Now, where does this lead? It leads, to my mind, to a fourth point, an interesting question about universities. Are they federal agents? Right, a federal agent, we assume, comes with a badge and a nice suit, and he arrests you or does nasty things. But are universities federal agents? Are they agents for carrying out the federal suppression of speech? The fiction is, of course, that no one is suppressing speech. Why is that? The government says, oh, no, we're not suppressing speech. Goodness gracious, no. We're just distributing benefits, and of course the conditions on these. But the universities do what they need to do. That's not our business. And the universities say, oh, no, no, we're not suppressing speech. We're just living up to the conditions of our grants. We have to do this. So everyone's going like this. And the result is no one actually is suppressing speech, and yet we have the most elaborate suppression since the 17th century. This is extraordinary. Now, if one steps back a little bit from this and looks at the administrative state, it's quite clear that administrative agencies at the federal level treat every single other institution as an administrative agent. States are now administrative agents of the federal government. State schools are, private businesses are, and private universities, and in many instances for regulating speech. So the reality is universities may in fact be agents for the federal government. By the way, the federal government is very well aware of this. I interviewed about 20 or so HHS officials, including the folks who drafted the regulations, and they're self-conscious. They say, look, we're not requiring any suppression of speech. This is no contract between the university and the federal government. Oh, no, no, no. We just give benefits, and the university gives us an assurance. And that's not a contract. You should never think it's a contract, because then, of course, universities would be federal agents. But where someone acts at the behest of somebody else, and indeed for money, it's difficult to think that they're not agents in some sense, and here in this case, to carry out policies that suppress speech. These are policies that the federal government knows, in great detail knows, that would be utterly unconstitutional if carried out directly by HHS. And that's precisely why they farm it out to other people. Now, if I were in another business and I wanted to carry out a hit, but I didn't want to get my hands dirty, and I paid one of you to do it, do you think either of us would escape the fury of the law? I doubt it. And this gets to the fifth point, my conclusion, which are federal remedies. If we have federal suppression of speech through federal agents, the universities, what should the solutions be? Now, one obvious one would be condition federal funds for educational institutions on their not abridging freedom of speech. That's easy enough. But this is complicated for reasons that Robert mentioned. It's very worrisome, moreover, to have the federal government intruding more into private institutions to cure the prior intrusion. One could, of course, simply reduce federal funding without any conditions on it, just to bring it down a notch, just as a gentle shot across the bow. And that may be good for other purposes because universities are too dependent on federal funds. But that seems rather harsh. And if it is to be done, it should be done for other reasons. Of course, one could have a new federal statute, something like Section 1981. It would read something like this: any person, individual or otherwise, who abridges or authorizes the abridgment of the freedom of speech or the press guaranteed by the Constitution under color of state or federal law, or under the color of any state or federal condition, contract, assurance, etc., should be liable in any state, court, or federal, etc., for damages. That would be nice, but again, that may be too broad. I think it's an open question as to whether that would be desirable, and I'm always hesitant to see more federal regulation of this sort. So I just want to leave with the suggestion that the solution is actually up to everyone in this room. One solution is just to talk about the problem and make people more aware of it. Another solution, for which we are all, I think, very well equipped, is litigation. And I'll just close by saying I think there'll be a lot of very amusing litigation on this subject in the coming years, and the universities will rue the day that they became federal agents for suppressing speech. Thank you.
Great. I'm delighted to be here. I want to thank the organizers, including some of my former students, for putting this together. It's a pleasure to be speaking with my fellow panelists. So you may or may not know that in the early 1990s, there was a great debate in the law review literature about hate speech and hate speech on campuses in particular, and that if you look at some of those articles now, including some written by people in this room, you will think that they could have been written yesterday, because the issues around race discrimination, around racism, around sexism, around anti-gay antagonism, around many other issues have been with us at universities for a very long time. And the questions of how we engage around them as institutions, as faculties, as students, as members of university communities, I predict will remain quite pressing for us now, and even if we were all to gather here again in 20 or 30 years. So my goal today is not to revisit the literature of the early 1990s, but instead to step back from the free speech versus censorship framing that is so often what people debate on these issues, and to ask you to think, and I should say, because free speech is an administrable rule, right? It's fairly easy to say, we'll let anybody speak, and we will enforce that person's right to speak. We will allow for and find ways to protect a person's ability to share their views. That's not such a hard question in certain respects. The questions I want you to think about today, or that I invite you to think about, are what are the costs, what are the consequences, and how else might we want to think about the costs and consequences of free speech within universities beyond just resorting to we need to allow it, and that's the end of the discussion. So what I'll do is speak first about our rules of university conduct here at Columbia, and then second, I'll explore three sets of costs or consequences that I think of as relevant to this issue. And third, I'm going to pose some more questions for you about this. So this is definitely in the vein of more questions than answers. And that's really my goal, and I think most appropriate with you as student, with most of you being students, is to lodge with you some very important questions for your consideration going forward. Now, at Columbia, I serve, in addition to all of my law faculty roles, as on the senior administration of the university. And one of the responsibilities I have is to administer our rules of university conduct, which govern demonstrations and counter-demonstrations on campus. I am speaking in my personal capacity only here, not in an institutional capacity, but what I want to share with you is informed by my experiences of administering our rules. Now, given time constraints, I'm going to focus in these remarks on thinking about these issues around invited speakers who are not affiliated with the university. There are, as Dean Post said, many issues around faculty speech, many issues around student speech, both in and outside the classroom. Hopefully we'll talk more about those in the Q&A. As a preliminary matter, just want to remind you of what you already know, which is that outside speakers get invited to campus in many different ways. Many of you presumably have invited speakers to campus. Sometimes faculty members do in their individual capacity or running a center or an institute. Sometimes the schools themselves do or the broader university. So at Columbia, like at many schools, we have a policy around these kinds of issues. We happen to have a 17-plus page policy, single-spaced, that reviews not only our values, but also the various procedures and so forth associated with this. What I want to share with you is something from the affirmative statement in our rules, because I think it's quite important for situating the conversation about how do we think then about free speech and its costs and consequences. So our rules say that they're intended to ensure that all members of our community may engage in our cherished traditions of free expression and open debate, that the university provides a place for ideas to be tested, for values to be questioned, and for minds to be changed with as few constraints as possible. Now, it has interesting connections to the point that Professor Hamburger was just raising about IRBs, but I'll set those aside for a moment. The rules stress the rights of demonstrators and of counter-demonstrators, and they explain that the limited restrictions that are imposed on disrupting university events and functions are justified not because they would prevent an opinion from being heard or stated, but to the contrary, because they protect rights of free speech, free press, and academic freedom. The rules are specifically and extensively content neutral. To be true to these principles, the rules say the university cannot and will not rule any subject or form of expression out of order on the ground that it is objectionable, offensive, immoral, or untrue. The rules go on, viewpoints will inevitably conflict, and members of the university community will disagree with and may even take offense at both the opinions expressed by others and the manner in which they are expressed. But the role of the university is not to shield individuals from positions that they find unwelcome. Rather, the university is a place for received wisdom and firmly held views to be tested and tested again, so that members of the university community can listen, challenge each other, and be challenged in return. And I'm sure Dean Post and I can exchange about this afterwards. But for purposes here, as a matter of rule of law, the rule at our university here is clear. If a speaker is invited, that speaker is entitled to speak and has protection against being disrupted, even by people who most profoundly disagree with the speaker's views. So the interesting question to me in this context is not, do we vet speakers for their views, but instead are the costs and consequences of having a policy like this in place. And my chief point is this, as I said at the outset, that much of the public debate, is it free speech or censorship, obscures some of the more important questions that arise when we think about bringing speakers to a university campus whose views may be seen by many as hostile toward what higher educational institutions identify as fundamental values. So this is quite related to what Dean Post was saying. Right? In addition to the exchange of ideas, values we hold dear are fostering education, advancing research and knowledge more generally. So let me suggest for you three costs and consequences that I would like you to think about as you think about these issues. First, there's the potential cost or consequence that somebody's presence on a college campus legitimates to the outside world their speech that in some way contradicts the educational mission, right? So elevates pseudoscience, elevates demonstrably flawed or debunked methodologies, elevates accounts of history that have been falsified or other facts that have been falsified. That is, I think we can trust on a university campus that these ideas will be debated, that the issues will be exposed, that students on campus in particular will have an opportunity to see that that there's a range of views. But that debate rarely carries over outside of the university setting. And instead, what we most often see, I think, is that, that many speakers will tout their presence and their speech at a university as a basis for granting them legitimacy. I spoke at X, Y, and Z universities, now I'm speaking to you. And the you audience, whether it's a radio show or a TV show or some other, or a community group setting, won't have had the benefit of the rigorous debate and conversation that will have taken place most likely on the university campus. One could say, in a sense, that universities and colleges are being used by speakers to elevate their legitimacy to the broader public. Second potential cost or consequence, that the speaker generates or exacerbates a hostile environment for students whose identity, intelligence, or activities are devalued by the speaker, often with a hostile tone or language that its targets argue have the effect of putting them at risk. Right? This is the more familiar ground for the debate. And what I want to, there are lots of examples here. I'm not going to elevate anyone in particular. I'm sure you all have your favorites in mind. I do want to be clear that in my university role, I hear this concern not only from the liberal and progressive students that the media tends to focus on in these issues, but also and extensively from conservative students who feel threatened or shut down by having speakers condemning their views as well. And so this presents, I think, a serious question for educational institutions. Right? So I recently saw a T-shirt that said, "If you're afraid to offend, you can't be honest." And I imagined also the counterpart T-shirt, putting together some other conversations I've had that says, "If you offend me, I find it difficult to learn from you." Now, on the one hand, we are at universities all about the exchange of ideas. On the other, we know empirically and anecdotally that students who experience their environment as hostile on whatever grounds are less likely to gain the full benefits of their education, right? And I think each of us, and I'd ask you to think about this as I'm talking, right? We've all sat in, listened to speakers where we have had the experience of seeing another person in the audience who's very agitated with the speaker and that person's ideas, very passionate about it, very offended by the ideas, and we've sat there somewhat curious. Oh, I'm not that offended, actually, or I don't know why you have so much passion about this. At the same time, I suspect we've all had the experience of feeling quite impassioned in reaction to a speaker and having those around us be puzzled at our own behavior. Now, when these ideas are about identity, and these sort of experienced attacks are about identity, whether mocking feminists or transgender students or skeptical about the Holocaust or skeptical about racism or skeptical about any number of other things, religious minorities certainly strong in issue today, or suggesting, for example, that conservatives are killing the environment or other people, I think we'd be naive to think this has no impact on students and on the student learning experience. Now, it does not follow automatically from recognizing this that the answer is to disallow the speaker. But to me, that is not the end of the conversation. That's the start of the conversation, and it is exactly what compels us to ask, then what might our obligations be? The third, just briefly, is that a speaker's, the third cost or potential consequence that I sometimes hear, I imagine you have, is that a speaker's ideas are dangerous in a particular respect to a population, to an environment, and that we are in an exceptional situation such that that speaker, setting aside even concerns about legitimating the idea outside of the university setting, setting aside the harm maybe to somebody's education, but that speaker is advancing ideas that endanger our world, right? So how do we think about this, and should we think about this in a way outside of conversation over cocktails? I want to ask you that question and suggest that yes, I actually think we each ought to think very seriously about our responsibilities in these regards, not only as individual students or faculty members or administrators or at the institutional level, but also as we think about our role in shaping and fostering higher education. So just briefly, I'll remind you, especially on the second point, the targeted attacks on populations, that Title VI and Title IX both prohibit discrimination in educational institutions based on race, color, national origin, and sex. It's well settled that this commitment includes non-discrimination for students in getting the benefits of their education. Multiple courts have recognized that misconduct of various sorts that creates a hostile environment can be understood to deprive a student of the benefits of their education in ways that create a violation of these laws. Now, having a speaker speak is not the same as misconduct of the sort of a physical assault, of course, but it remains the case, as we know from a range of empirical literature, that there are costs, again, to speech. That the idea of, that sticks and stones won't break my bones, will break my bones, but names will never hurt me, that is fairly well debunked in the empirical literature. And so the question, again, for us is, what do we do? Going back to the law review articles of the early 1990s, there was a lot of sense of this is very hurtful speech, it's problematic speech, but there wasn't as well developed a body of empirical literature demonstrating the consequences for students' educational experiences. We now have more of that. Surely there will be more to come. And so, again, in the vein of leaving you with more questions than answers, I'd like you to consider what then, if we are not going to stop the speech, and I'm not contending we should, I actually don't think we should, but if we are not going to stop the speech, what are our obligations and how might we think about responding?
If I were speaking to a similar group at the American Constitution Society, as I like to do, I would spend more of my precious time documenting the sad state of freedom of thought on American campuses. But I'm guessing in this crowd I don't need to do that because you're all painfully aware. I do want to mention, though, a recent statement just about 2 weeks ago. John Etchemendy, the longtime provost at Stanford University, where I teach, and one of the most respected figures in higher education, took the occasion of his stepping down to make what I think is a very important statement, and I would recommend that all of you look for it. It was entitled "The Danger Within," and he begins by talking about various threats to higher education, funding cuts and this and that, and that's all sort of familiar stuff. And then he says, but I'm actually more worried about the threat from within. Over the years, I have watched a growing intolerance at universities in this country, not intolerance along racial or ethnic or gender lines. There we have made laudable progress. Rather, a kind of intellectual intolerance, a political one-sidedness that is the antithesis of what universities should stand for. It manifests itself in many ways, in the intellectual monocultures that have taken over certain disciplines, and the demands to disinvite speakers and outlaw groups whose views we find offensive, and constant calls for the university itself to take political stands. It goes on to say that this results in a kind of intellectual blindness that will in the long run be more damaging to universities than cuts in federal funding or any of the other things we've been talking about at the beginning. It will be more damaging because we won't even see it. We will write off those with opposing views as evil or ignorant or stupid, rather than as interlocutors worthy of consideration. We succumb to the all-purpose ad hominem because it is easier and more comforting than rational argument. But when we do, we abandon what is great about this university, institution that we serve. So maybe even in mainstream academia, folks are beginning to notice the problem that I suspect most of the people in this room have noticed. I mostly want to talk about what we can do about this. Before I do that, I do want to just say two things as a preliminary. One is, you are not the victims, and you don't, and I don't have a lot of patience with whining. Yes, it is unfair. Yes, it can be painful. but you've been through the refiner's fire. You don't go a day in your education without being challenged about the nature of your assumptions. Why do you believe what you believe? And you don't go a day in your education without having to figure out how to communicate with people who don't necessarily share your presuppositions. You are getting the finest education that young lawyers can get. The victims of this one-sidedness are your liberal and progressive fellow students who can go through an entire education without ever having their precious beliefs challenged and without needing to learn how to make a real argument, to make instead arguments of the form of check your privilege, which I think is left-wing ideology speak for shut the hell up. And there is one other set of victims, and that's society as a whole, because universities and especially law schools are raising the leadership class of our country, and I fear that we are raising a generation of people who either do not understand or do not believe that there are two, and oftentimes more than two, legitimate points of view, and who believe that disagreement is something that can be suppressed. I think this is a major reason for the much lamented extreme polarization that we are already seeing in our political culture, because it doesn't take very many classes of university students who have no sympathy or understanding or empathy for the other side to produce this kind of an effect. So now to what I really want to talk about, which is what can be done. And specifically what I'm asking here is, or going to talk about, is what can you do, assuming that you care? What can you do? And what can you reasonably go to your universities and your law school deans and ask to be done? And in order to know what to do, you need to divide the problem up, because I think there are basically three quite different sets of problems. One has to do with university policies. One has to do with other students. And the third, sort of all-pervasively problem, is the one-party state. Now, as to university policies, this, I think, it's going to be extremely difficult, but it's the most straightforward of the three areas. The first thing that I think you can reasonably ask for, and you should be asking for, is that the university be clear what its policies are about speech and diversity of expression on campus. Here, the University of Chicago, led by my former teacher, Jeff Stone, is, I think, the model. Not every university is going to be willing to be as clear and forthright as the university. Here's the Chicago statement, the key sentence. The university is committed to the principle that it may not restrict debate or deliberation because the ideas put forth are thought to be offensive, unwise, immoral, or wrong-headed. It is for the members of the university community to make those judgments for themselves. Are there exceptions? Yes. Narrow defined circumstances. For example, speech that violates the law is threatening, harassing, or defamatory, or invades substantial privacy or confidentiality interests. Essentially the same restrictions that freedom of speech has out in the rest of the world. But even if your university is not willing to go the full Chicago, you're entitled to know what the policy is. And if the policy is not very free speech friendly, you're entitled to know that, and so is the public. So asking for a clear statement of policy, I think, is important. But in addition to university policies, which are very important, I also think you're entitled to ask for university leadership with respect to helping to set a tone for free-spirited discussion on campus. Here again, John Etchemendy says, in this, he says, the first step, he says, is to remind our students and colleagues that those who hold views contrary to one's own are rarely evil or stupid and may know or understand things that we do not know. It takes so little. Right after the Trump election, things at Stanford Law School were, I think, maybe a little better than I hear from elsewhere, but we had a cry-in, and it was really pretty bad. And the university administration issued a statement. It was kind of a funny statement, but it was really quite helpful. The statement came from the Career and Pro Bono Office, and it said that we know that some students in the law school will be seeking positions in the new administration, and we have resources and contacts to make available to them. Now, I think that was a lie. I don't think they have any contacts at all. But I would be the closest one, and I didn't have any contacts. Not being exactly Mr. Trump Central, but the message that this sent out is it was telling the other students, remember that among us are supporters of this administration. Part of our community is not thinking that this is, as one of my colleagues said, the worst thing to happen since 9/11, right? And I think just to be aware of other people and that they exist and that they are human beings too, I think that can be helpful. Next thing that I would ask our universities to do is, and I'm taking a leaf here from the sexual assault program, is there ought to be an environmental survey. This has been required with respect to sexual assault to determine just how prevalent the problem is. And I think a survey of the students, and maybe faculty too, about whether they have felt free to express their views in class and out of class, whether they've ever felt physically threatened or threatened in some other way when they do that, I think that would be very valuable information. Until we find out the extent of the problem, it's always going to be possible for the Pollyannas, the ideologically motivated Pollyannas, to deny that we have a problem at all. And then I also would suggest that universities establish some kind of an office like an ombudsman somewhere where students, maybe faculty and administrators too, but especially students, can go when they have a situation in which their free speech rights, pardon me, maybe they're not free speech rights, whatever they are rights on campus have been violated for if they believe they've been graded down because they disagreed with the professor, if they have had as many conservative student newspapers are stolen en masse in order to make sure that they don't get, if they're, as I believe happened at Harvard Law School, although people here could correct me, as notices were ripped down from what supposedly were public notice boards, things of that sort, if there were a place where people were entitled to go, and I don't even know what redress they should get, but I think just knowing that the university cares enough to give them a place to go with their legitimate complaints would be very helpful. Now, how do you get this done? The first thing is you should be requesting meetings with, I don't know if you can get through to the university president, but you can surely get through to the law school dean and to other folks. You should go not by yourself, I think no more than 3, but you should go in a group of 3. if you can. You should be respectful. You should be constructive. You should be well-informed. You should not complain about things unless you really know what happened and have thought about it. And in addition to the meetings, you should write. You should take advantage of university publications to publicize problems and to write and to talk about what the university ought to do. You should petition. You should offer to debate. This is a really good thing to do. If we're right about this, people should be willing to debate it. You should put on symposiums and panels. So here's a concrete suggestion. Ask the American Constitution Society at your school to put on a program about this subject with a balanced panel. And if they're reluctant, and maybe they will be, I don't know, offer for the Federalist Society at your school to put a panel on a subject that they think we ought to be thinking about more seriously. I think that's a great idea, even if... Another thing, establish committees of correspondence with other FedSoc chapters around the country so that you know what other people are doing, so you can find out, you can swap best practices, you can say what works, what doesn't work. We've got this great idea, don't do this. Committees of correspondence would be helpful. Now, as to other students, this is the trickiest because other students have just as much right to criticize you and me as we do to criticize them, right? We do not, if microaggressions are if the idea of microaggressions is an offense against freedom of speech, let us not do whatever the converse is of macroaggressions, whatever it would be. But violence and threats of violence and trashing of property and interference with notices and interference with meetings, these things are not mere criticism, and I think we are entitled to ask for protection from the universities. What happened at Berkeley was an utter shock, but then just yesterday, I believe it was at Middlebury, there was a similar violent incident. I have not heard of arrests and retribution on this. I very frequently hear of things like this, the theft of newspapers, where there's evidence of who did it, and universities doing nothing. This is something can reasonably be asked. Also, part of the University of Chicago statement that I read before says the university has a solemn responsibility not only to promote a lively and fearless freedom of debate and deliberation, but also to protect that freedom when others attempt to restrict it. The university has an obligation to protect, right? At Berkeley, they knew what was coming, and they did not protect. They had very few guards, and the guards did almost nothing about it. Right? That was a dereliction of University of California's responsibility to the students and to freedom of speech at that institution. Now, I think I'm out of time, so we can't even talk about the one-party state. Catch me at cocktails after dinner, and actually after 2 cocktails after dinner, and we can talk about that.
Okay, comments from the panel on remarks from colleagues.
Thanks. So this was very interesting. I quite agree with Mike about the one-party state. It's depressing. I thought that was over there in Eastern Europe, but perhaps not. And I guess that my only real comment is about what I'd call an equality of insult. I think the notion of insult is actually very important in all of this. And I worry about the illusion that we have really content neutrality on campus, or that universities take insults seriously. Whether or not they should be, the reality is different, as we all know. And the reality, by the way, goes back to my youth, which means we're talking at least a half century here, right? Sad to say. So think about the uses of insult. Insult is treated by the university as a mode of demeaning somebody else, whether intentionally or just negligently, and that's very hurtful to them, it's said, although whether people who feel hurt by words should be engaged in academic inquiry is another matter. The awkwardness is it serves another purpose, as we all know. It's a marker. It demarcates the boundaries of legitimate inquiry and speech. And so if an insult is accepted without repudiation, then it becomes a line beyond which one does not go without at least peer pressure. And that leads one to think, is there really equality in these matters? And of course, the answer is no. My first week of teaching, the dean at my school, a state school, mind you, said, "Oh, you're going to be our resident fascist, I see." And I knew from that moment onwards it wasn't going to be the intellectual experience I expected. And this is pervasive, right? Let me just take two, I don't want to whine, but I do want to take two phrases. And I must say, I was brought up to be a gentleman. I would never want to insult anybody. It seems to me antithetical, not merely to academic inquiry, but to who I am. Nonetheless, let me take two phrases that I think are more or less parallel. One we hear quite commonly, I've heard many times in my life in academia, chauvinist pig. No one wants to be called a chauvinist pig, even if they are a chauvinist pig. And what's the equivalent on the other side? Feminist bitch? I mean, it's not even a phrase I want to use. But degrading somebody as an animal on account of their enthusiasm from one sexual perspective or another. We all know which phrase is used. We all know what would happen to teacher or faculty if they use the one phrase rather than the other. And when one understands just how prejudiced the application of university generalities can be, one begins to realize that what we have here is a serious problem, and it comes with federal funding, and it's common to state schools, and I started at state school. There are First Amendment issues here.
Great. So I want to speak to the university's obligation as an educational institution, because Judge McConnell and I probably disagree on many, I know we disagree on many substantive issues. I do want to strongly disagree with much of what you said about engaging in the university community, participating. And in particular, I want to highlight a through line to what you were just saying, which is that universities are educational institutions, right? You come in, we've all come in as students not knowing everything, right? Certainly as faculty, we don't know everything. But one of the things that's critically important, I think, to learn as a student, both in the undergraduate and then in the graduate school setting, is what do you think? For undergraduates, identity formation is particularly important and critical. And psychologically, we know that sort of the 17 or 18 to 23-year-old stage is very important developmentally, and it goes beyond that. It goes throughout our whole lives. So that the obligation of the institutions is not just to say you've done something wrong by tearing down the other group's flyers, which has been happening at universities for time immemorial on many, many different issues, some politically motivated, others not so much, or taking each other's publications, but to really help people in that process not only sort of engage in a disciplinary function, but really understand why it is so important to understand what others think, right? As Judge McConnell said, people who we disagree with rarely have nothing to their argument. Now, I assume everybody here knows that as law students or lawyers, because we can't be effective advocates if we don't deeply try to understand the arguments against our position, right? That's been essential to me in all of the LGBT rights and the other gender and sexuality work that I've done over time, and I think it's essential for anyone anywhere. So the question, again, I encourage you to think about is how do we make that real, right? How do each of us, regardless of our political views, make real this learning process of understanding the positions of others and responding to them, engaging with them, perhaps reflecting on them as we develop our own arguments, because again, the argument's never over, right? It's never over after you win a case. It's never over after you close the deal. We live in a dynamic world. These issues are dynamic. I think the last, I don't really want to engage in particular disagreement, but I do feel it's important to just note 2 points. One, in terms of Berkeley, my at least read on this is that there was actually not an expectation that outsiders would come in and agitate. And so I think we can disagree about what the facts were, but I just want to voice that has certainly been part of the coverage there. And second, with respect to my beloved colleague, Philip Hamburger, who I think we've been friends from day one, on the balance between sort of sexist insults, I take a different view about which sexist insult is probably made more often. But my point really isn't sort of the disagreement about which one is made more often. It's really to encourage you to think about the consequences of using those kinds of stand-in shorthand dismissals of the ideas and views and identities of others, rather than to try to engage deeply and in this educational setting really learn from people who you see as different from you.
I think a lot of what Michael said is really quite wise, and you should take it to heart. There is a sense in which if we're going to have an educational institution, it has to be experienced as equally available to everyone there. That's a crucial premise, I think. And you see that I see it as a dean, I see it on all sides of the political spectrum. There's no monopoly there, left or right, I should say. I want to emphasize that when you read policies like the Columbia policy that Suzanne read, or the Stanford policy, these are educational policies. So a university decides to allow all speakers or students to pick their speaker free from constraint because they view it as educationally sound policy to do that. Bob Jones University might have a different educational policy, a different idea of what can educate their students, and they are under no obligation to have Louis Farrakhan as a speaker if they don't view him as advancing their educational policy. So it's going to come down to what a university thinks it's teaching. And I think what you see in the major university policies like Chicago is we are teaching you how to be in a political space where there are going to be others. And those others are going to disagree with you, and how you tolerate and deal with disagreement. And one crucial fact about dealing with disagreement, which Michael stressed, is that when you are in a political space and have a common political destiny with the people you are disagreeing with, they are not your enemies. They are co-citizens with you. So if you're going to draw this friend-enemy distinction, you can't be in a common political space. Carl Schmitt, to the contrary, notwithstanding. And that's a crucial insight that educational institutions are trying to give by allowing speakers of all stripes to come to a campus. And if they do, then they are under the obligation of protecting those speakers and making sure that the audiences can hear them. I think there is an ambiguity that one gets out of the idea of offense and hostile environment. On the one hand, I find it offensive, that is to say, I am subjectively offended by what is said, and on the other, I don't like those ideas. And we can, I think, if we're going to have an educational institution, we're going to have to very sharply distinguish between ideas being offensive, and that has to be ruled out. All ideas are on the table to be evaluated, and forms of address which are offensive. None of us like to be called chauvinist pig to our face, and no one should be called chauvinist pig to their face in a classroom. And we should be able to regulate that. That's distinct from saying Title IX should be thrown out. We should be able to say the latter, but not the former.
I think this very brief comment will follow well on the last two. I think I should clarify, when I was talking about the phrase chauvinist pig and so forth, I was thinking actually about academic talk as opposed to personal talk. The university now regulates our personal interactions as well as our academic interactions. And unfortunately, this gets to the problem of insult. Much academic analysis these days now includes what can be read as a sort of insult. To call somebody a chauvinist pig is actually something not uncommon in a classroom. It's not uncommon even in academic writing. And a large part of, I unfortunately, left political analysis actually elevates words which I think, taken on their face, might be understood as insult. I'll take one, for example, homophobic or Islamophobic. Again, I'm personally abhor insult. But the unfortunate thing about these words is that they identify a position all too easily as a sort of medical condition. And that's just not conducive to serious inquiry. I teach, amongst other things, by the way, early Islamic law, unbelievably. And we do so in an entirely unprejudiced way, in a way that I hope is open and of interest to everybody without any sense of insult. But the danger is that in most university discussions of these matters, names are used, and academic analysis sort of includes insult in the very terms of engagement. This just isn't helpful. It actually just stirs up more disagreement than is necessary, and it gets back to the danger that we have an establishment vision of what's acceptable talk, and then the disestablished vision.
All right, so we have broad agreement on the panel about the virtues of diversity of opinion and free speech, particularly encouraging respectful interaction among people who disagree. But just briefly, I'd like the panelists to address the question of whether our topic here is a little bit just too broad. That I sense from your comments that you don't view the university as a monolith, that freedom of speech will differ depending upon whether you're a teacher in the classroom, whether you're a student in the classroom, whether you're students out on the quad, whether you're a teacher engaged in research, or whether you're a teacher/student that chooses to invite an outsider in as a guest on your campus. Anybody care to comment on those? Are we looking at, different tests, different evaluations for those?
I certainly think that's right.
Turn on your mic.
I certainly think that's right, and I appreciate Dean Post's comments because, I mean, it is important for us to realize that most of the issues on campus are not actually sort of free speech doctrine issues, as if we were talking about, municipal regulation of demonstrations. Now, there are aspects of university life that I think could and should operate very close to that. They are outside of the classroom, outside of the professional, academic, scholarly function of the professoriate. Students are living there. When the students are in the dorm and in the eating halls and going to and walking across campus, that is their home and it's their town, and it is very much like a town, and I think it ought to operate very much that way. The classroom, as he points out, isn't. So I do agree. It's helpful just to be reminded you don't just plug in, doctrine, First Amendment doctrine to this. You have to think, as he says, about the educational function, and that does mean that there are going to be different rules for different things. And I mean, take, for example, the issue of invited speakers, which both Suzanne and Bob spoke about. Universities invite who they want. I'm personally quite irritated when you look around the country at who the commencement speakers always are. There's no, it's just no ideological diversity at all. That is not a free speech issue. It's a point of annoyance to me, but it is not a free speech issue. They are naming their commencement speakers in order to please the audience that is there. But when a speaker like Charles Murray at Middlebury yesterday is invited on a legitimate basis and then can't speak because of the violent disruptions, that is a free speech issue.
Why isn't that just an educational failure issue?
Well, the way I see it is that it may not be the First Amendment free speech issue, but freedom of speech is at a kind of freedom of speech in the right place at the right time is part of the educational mission. And the reason for that is that universities are raising up the citizens of the future. And one of the things we should be training our students to do is to engage as democratic citizens, and that requires being able to deal with difference of opinion.
Right. All right. I was going to go to questions briefly. Go ahead.
Oh, go ahead.
All right, well, let's go to questions, and then we'll try to weave in comments. The lights, yes, sir. Oh, please state your name and affiliation, and no speeches, just questions. Just go loud. I'll repeat it. Go ahead.
Sorry, I just wanted to ask Professor Goldberg. Now, your first point was about legitimacy. You're worried that invited speakers to the university campus might somehow have a use legitimized on the outside world, for example. So that might be a reason to restrict their ability to speak on campus. My question is, would maximizing freedom fix that problem? So if every university allowed everybody, or allowed speakers regardless of whatever it is they're covering, wouldn't then it lose its luster? Saying that I spoke at Harvard, Yale, Columbia, whatever, wouldn't really mean anything if every single university maximized the amount of freedom.
So let me just clarify, because I didn't quite say, I think what you just said. I don't identify this as a worry. I do think that there is a question of a real question, an importance to understanding that when a speaker comes to whatever college or university, that for many speakers, particularly for those who hold views that are far outside of the mainstream, whether right or left, that becomes a kind of feather in a cap that people usually tout, right? I spoke here and I spoke there, and therefore if I said something that's of importance to a university community, it should carry greater weight. Now, I think what you were saying is, well, if all universities and colleges allowed anybody to speak on their campuses, maybe that weight would be diminished in other settings. And I guess I am skeptical. I see your point, and maybe there would be a marginal difference, but I actually think that higher education institutions do hold a special place in our society, that people, generally speaking, even if they mock those of us who work here for being too academic, also understand generally that these are places where people take ideas seriously, places where people try to advance research, advance knowledge, and that being affiliated in some way, even if just as an occasional speaker in these settings, does give a kind of gravitas that one doesn't necessarily get from speaking elsewhere. So I don't think a general policy as we have here of allowing anybody to speak will overcome that. Now, I'm not saying, just to be very clear, that that's a reason for disallowing speakers. I am saying that that is a consequence of allowing speakers and something that we shouldn't be naive about, whoever is speaking in our institutions.
Yeah.
So, I don't know if my microphone is working. I'm sorry if it's not. Rebecca Duncan from Cornell Law. So hopefully this is a question with an actual concrete answer. I'm curious, what are the underlying legal structures to some of these questions? Because I think it was Professor Post threw out the difference between maybe like a Bob Jones University and like a public university with their practices of like who they might invite. But I'm wondering if like the ideas of like a limited public forum, and the idea that if a government entity here, like maybe a publicly funded state university, opens up a limited forum, you're not supposed to engage in like viewpoint discrimination. Does that not apply to these situations? Is it truly just a question of educational goals? And are the universities themselves the only ones in charge of answering these questions, or does First Amendment law actually apply in those situations?
That's a terrific question. So, as you know, the First Amendment doesn't apply if you're not a state actor. So we're talking here, if you're talking First Amendment, you're talking about state universities typically. And as to state universities, the court has said that the state university can regulate speech as necessary to serve its mission. And if it didn't say that, then of course they would have to tenure all professors because they couldn't make content discrimination. Everyone would get an A, this sort of thing, right? All the children would be brilliant, etc. So the question of whether they've opened up a public forum, that's precisely the right doctrinal question to ask. And typically a court will answer that by saying they've created a limited purpose public forum. But if you look very carefully at limited purpose public forum doctrine, you'll see there's almost no constraints on the purposes, the limited purposes for which you open it up. So those purposes are going to be redefined at the front end in terms of educational objectives. That's the way it would work doctrinally.
Except that except the main limitation on limited public forums is that those limits cannot be related to the suppression of unpopular ideas. And so that has real legal bite.
Well, once again, so let's say that the limited purpose is to serve the interests of the biology students. And that's your limited purpose, and you say no creationists. My guess is that the court would uphold that even though it's a form of viewpoint discrimination. So yes and no.
Yes, sir.
Nick Gallagher, NYU Law. Thank you, Your Honor. Dean Post, you articulated, sorry, I didn't know this was on. You articulated, and I really appreciated, some first principles on how the university worked that sound a lot like Bill Buckley and God at Man at Yale. You know, a pre-1960s revolution idea of an educational mission that's positive rather than grounded in simple freedom for the students and the professors to explore as they wish. But before that revolution, there was also a great deal of consensus that the university would act as the sort of in loco parentis, and also that it had to be kept very much in the mainstream of the American public's ideas on what should be taught, and that was an important point that the public could concern itself with. If we're going to return to that type of system, do those things then come back in? If not, why not? And what's the justification for returning to it beyond the right people won and now they're firmly entrenched, and so let's get on with it?
Again, that's an excellent question. So I don't think there was ever a time when the American university was simple freedom to act as you wish. If you look, for example, at the foundational statement of academic freedom in the United States, it's 1915 by the American Association of University Professors. Very strong statement about the university having missions involving research, involving education. The American university, since the 1880s, when it turned into a research university, before that it was a finishing school for young Christian gentlemen, typically speaking. But after we learned from the Germans about Wissenschaft and actually creating new knowledge, the American Professoriate and the American Association of Universities understood itself to be engaged in the process of educating young persons for adulthood to become citizens, as you've heard, and of expanding knowledge. And the in loco parentis as an understanding of the education kind of ended in the 60s. The fundamental premise of the free speech movement was you can't regulate us in loco parentis. Remember in the free speech controversy in Berkeley, it was about the university penalizing students who had gone off to demonstrate in the South, committed illegal acts, and hence were being penalized back at Berkeley. And they said, you have no jurisdiction of what I do outside the university's purview. So this role distinction between being in the role of student and being outside the role of student was a denial of in loco parentis because the parent has control over the whole child. A lot of what you're seeing now in higher education, and in particular some of the like the regulation of that fraternity, I think it was in Oklahoma, that was singing in the bus outside of the purview of the university, I think goes to a controversy of whether we want universities to be in loco parentis again. A lot of the controversy you see about safe space is about whether we want to return to in loco parentis. And that's a very controversial issue about what we want our higher educational institutions to do. Do we want to take charge of the whole student or just the role segregated student that's very tightly connected to the instrumental task of education?
I think there's a connection between the last two questions, because what's different from the past is not really a degree of control within the university, but the degree of control from outside, from the federal government, and sometimes direct, sometimes through the conditions. And eventually, that will have consequences. One cannot keep the First Amendment out of these situations. But these are areas of doctrine that have yet to be explored.
If I could just add one quick point, just in terms of thinking about these questions in a broader context of how higher education institutions regulate students. There's really a tremendous web of regulation of you that you are probably more familiar with than some of us are. But from the moment you enter an institution, you have obligations related, some imposed by state law, others by the school, related to vaccination, related to illegal file downloading on the university's internet, related to can you have halogen lamps or candles in your dorm room, related to myriad things, right? Do you have to have health insurance? Do you not have to have health insurance? And so it is useful when we think even about questions of in loco parentis, and when we think, or it is useful to think about the many different functions that the university serves and the kinds of regulatory environments it needs to create, or whether it ought to create, to carry out those functions. They're not, the same. We will not analyze the halogen lamp risk in the same way as we would analyze the risk of disinviting a speaker, but the educational function of the institution, as well as the function of the institution to enable all students who come to it for an education to have that education, is quite complex and we benefit from situating this conversation to some extent in that one.
It does seem to me that universities are beginning to act sort of selectively in loco parentis again. This isn't just a free speech thing, but a lot of it does have to do with speech. When you think about controversies over, even Stanford Law School has been known to take an interest in what students are saying over Facebook. Yale took an interest in what Halloween costumes its students were wearing. I think this is a rather radical change from when we were in college. I mean, I just think there would have been an explosion if the university had expressed the slightest interest in regulating what we wore as Halloween costumes.
I also think, though, and this is useful to keep in mind, there's a very different relationship, not only from the university toward its students today, but from the students toward the university. What the students expect and ask of university administrators and of faculty members that are really quite different from the sorts of things that many of us might have asked when we were in school. Again, it's not to diminish the significance of these questions, but it is to say that the relationship between students and schools is not static. So when we look to the in loco parentis questions of then and today, that we're really working in quite a different world. I don't think most students saw themselves as consumers of education until much more recently than, say, any of us on this panel were in school.
So Suzanne is so right, and this is so shocking to me because a lot of this in loco parentis meddling in students' lives is at the behest of students who go running to the grown-ups and asking them for the interference. And I say, grow up.
Maybe a future panel will be on the synergy between helicopter parenting and helicopter administrating.
I was just out at Stanford, and I was on a panel with Liz McGill, who's the dean out there, and she was saying one of the new points in law school administration is when we were in school, you would never ask for a statement from the school about this or that or the other thing, and now routinely you get students asking you, make a statement about Black Lives Matter or make a statement about the election of Trump or something like that. And as Suzanne is saying, this is coming from the students, so the change in the nature of the education isn't just one side, it's two sides.
And I do want to resist the idea that it has come, as is often framed in the popular debate, that it is coming only from liberal or progressive students. I think it is coming from a range of students who have a range of experiences while in an institution that they feel are interfering with their ability to learn. It's not to say, again, the issues are complex, but in the spirit of trying to understand those with whom we disagree, I think thinking back to the question of what are the consequences of, say, a fully free speech environment is a useful one.
Right, this gentleman wins the award for the most patient
Thank you.
potential questioner, sir.
I was going to ask for the whole panel's opinion, but I don't know. Okay. I'm 56. I'm a non-lawyer member of the Federalist Society, and I went to Michigan. And I was in Michigan as a student when Reagan won. I've never seen anything like this before, where the students are demanding the silencing. That is very, very concerning to me. What dynamic do you think is involving this? Is it technology? I mean, I don't see students before wanting non-white only spaces. They want, safe spaces. They damaging property, but for these reasons. Is there something through your illustrious careers you see different in people that are doing this?
Yeah. So that relates to a question I was going to pose to the panel, which is the heckler's veto. Is that not a concern here? I mean, if I were a dean, I would want everyone to be happy. I want them to have a great experience. I want them to donate after they graduate. And so, especially that the dean. So I have that in mind. I want free and open and respectful dialogue. But when one group or another brings somebody who is known as controversial, is there a risk that if the hecklers are organized enough and loud enough that we never hear any controversial speech on campus? I think is that consistent with your question, sir? Yeah. So do the students have, do you fear a heckler's veto among student groups on campus that will suppress free speech on your respective
I want to push back on the assumption that's come up that students are requiring this. Some students ask for this, and other students don't. And the real question then is, why does the university listen to some students, not others? There could be a political explanation of this. There could also be an explanation that comes out of, frankly, university council, which university councils tend to be, strategically have made, I think, a bad choice. They assume if you want to avoid litigation, what you do, you respond and control, and you have to then control more and more and more. Although at a certain point, that means best practices will be to control, and the result will be if you don't, you'll get in trouble. So the universities eventually will pay a price for this. But it may come from many directions.
So I'm not sure, and I can really only speak from my experience here, what the general counsel or any other office would be seeking to control in terms of speech on campuses, but that has not been consistent with my experience of this clamping down. I think one of the real differences between colleges and universities or higher ed institutions today and 40 years ago is that the student population is really substantially different. Right? It is more racially diverse, it is more economically diverse, there are greater numbers of women on campus, there are greater numbers of first-generation students on campus and low-income students on campus, there are greater numbers of international students on campuses. And so what does that mean? By definition, it means the nature of the environment is one that is different from what it was a couple of decades ago, which raises questions. Does the university, to what extent, if at all, should the structures of the university shift in order to ensure that this more diverse student population is fully gaining the benefits of the education that they signed up for and are paying for? So it's not to say, that doesn't answer the question of what to do, but I think it's an important factual baseline to keep in mind when we think about why some of these tensions are rising now in ways that they didn't earlier. And I think, an analog example, or a sort of somewhat attenuated example is people, many people have said, well, why do universities address issues related to sexual assault? And is that all new, right? Was there not all of the sexual assault before the past couple of years when the issue has come up? And if you pay attention, maybe to people you disagree with, or maybe people you agree with, I think the conversation would be, actually, those circumstances haven't changed. What has changed is people's willingness to identify some of the issues. I think you could see the same thing. I mean, to take a very different context, right? Has drinking and drug use changed on college and university campuses, and does that require schools to interact differently with their students because of these kinds of behaviors? On one version of the story, yes, there is a difference. There's more binge drinking. There's a wider variety of drug use. On another version of the story, no, it's really not so different, right? There was a lot of heavy over drinking and over drug use. There has been for many decades. And the question again is, what are the expectations that both students and parents of students bring to universities in terms of addressing these issues, and what are society's expectations around addressing these issues? We don't live in a static environment. Universities, fortunately, are not static places. So again, how do we interact, and what are the issues we need to think about in making policy?
Thank you all for being here. My name is Bennett Hampelos. I'm also from Cornell Law School. Ideologically, for full disclosure, I'm probably more with Professor McConnell, but this is FedSoc, so I'm going to provide, devil's advocate argument here, where if the right to free speech is absolute, and you can obviously there are exceptions to that, but when a speaker is invited to campus, many times there's a duty on the university to pay for security, for example. And it's unfortunate that the state of affairs has gotten to that to that point. But suppose we're not dealing with a university with a very large endowment like a University of Chicago, a smaller college, community college that doesn't have the resources to put up several $1,000s every time a very controversial speaker comes to campus. So in those cases, would there be an exception where the school would have to say, hold on, we've used up our resources for the year for controversial speakers. We literally can't afford hiring a small army to defend from looters and rioters and everything. Would there be a possible exception in those scenarios?
So that's a great question, and there's no easy answer to this. The great question, and there's no easy answer. If this were a city, that is, with the full First Amendment applying, the Supreme Court held in a case called Forsyth versus National Social, basically a Nazi party, that it is unconstitutional to charge a group for the privilege of exercising the right of freedom of assembly more because of the anticipated violent reaction of others. That's a kind of a heckler's veto. I'm a little skeptical that could or should be applied even to public universities, but maybe. But I do think this. I think universities ought to do their best to come close to that. And I think it will be cheaper in the end if the first time this happens that they hire all the guards they need and arrest the people who commit violent acts and make it clear that hecklers' vetoes are not going to be successful. I think the expense comes from doing it on the cheap and letting hecklers' vetoes succeed, and then they're going to have one of these things every time there's a speaker that groups don't like.
All right, we started 5 minutes late, so that means we have 5 minutes, but I want to end on a practice tip, and I think Judge McConnell will agree with me. We usually allocate 15 minutes aside, and for reasons that none of us quite understand, even lawyers that are tremendously ahead in winning their case are disinclined to sit down with 5 minutes left on the clock, and they just keep going. But I think this panel's done such a great job, we're going to quit before the red light comes on, and let's congratulate them.